Hi, welcome back. This is number 5 in the series of the process for religious exemption and the conditional acceptance that I've submitted to my corporation as of Friday. This is not legal advice. This is simply for entertainment and information purposes. That is my disclaimer. This is a matter of my conscience and my convictions. I'm not rallying a flag. I'm not trying to sway anyone to my position. This is simply a matter of public record at this point. Okay, with that said, we're looking at this as an ETS. We're also looking at this under a mandate, which falls under color of law. And if you don't know the difference between color of law and positive law is legislated. It is recorded in the amendments to the Constitution of the United States, preferably organic, not the Act of 1871 version, with the creation of USDC, which created 2 more classes of citizen, followed up by the 14th Amendment. Anyway, not to get into that too deeply, but if you see certain keywords, code words, keywords, I guess would be less hostile. If you see mandate, code, rule, statute, act, administrative order, guidance, standard, when you see these terms are created to offer up something that has not been positive law, which is not legislated under positive law, but under what's called color of law. It looks, smells, and tastes like a law, but it's not positive law because it doesn't impact, affect, or under this, all persons are not included. It's for categories and classifications of persons. For example, to request a religious exemption from my employer, I have to be an employee. That is my classification. Correct? Okay. These are not enacted under positive law. They have not been voted on and passed. They have not made it to the amendment phase. They're under color of law. And with that said, I want to make it abundantly clear that the First Amendment stands. There is no religious test for either public office or public trust. And if there's not one for the people that I've chosen to represent me, either in the executive, administrative, or legislative branches of my government, there can't be one for me as well. To get deeper into that, I want to look at it this way: sincerely held beliefs, the religious test, as it were. And I know I touched on this a little bit in the second video. But my question still stands: how are you going to test that, and by what is your exact criteria, right? And I touched on a little bit with this, because the question is, how long have you held them, and how do they impact you, your sincerely held religious beliefs, seriously held beliefs, and if you have ever met the criteria in the past, if you've ever taken a vaccine, if you have ever worn a mask, and the question of how does this impact your sincerely held beliefs. Well, those questions are meant to address from 2 sides a religious test: the substantive or functional, right? And I want to give you the Kavanaugh example of that. For example, the Kavanaugh example: if a Christian devotes his life to the stock market, the Christian that devotes his life to the stock market is, not metaphorically, but functionally, a capitalist. That is their worldview, and that is how they worship. The worldview is how you look through life. And again, whether you're Christian, Muslim, Buddhist, Zen Buddhist, pagan, Luciferian, religious, atheist, agnostic, is irrelevant. These are your sincerely held beliefs, and this is the worldview that you see the world through. This is your worldview. This is how you process the incoming information from the world. That is your religion. That is your God. And how you function in the world, is your worship. Okay, so herein lies the challenge. If I'm going to hand over a God-given right and constitutionally protected and other agency protected, and hand it over to someone and say, roll it around a little bit, see if it fits your substantive or functional criteria of a religious test, and then allocate a measure of that right back to me as you see fit, one, is ridiculous and asinine, and two, has no understanding of the organic Constitution of the United States. So, if in point that they suspend the Constitution, which is what they've been attempting to do, even through the military, they've been attempting to suspend the Constitution under this emergency to make it not a question of constitutional or unconstitutional, it becomes a non-constitutional issue, right? This declared state of emergency, or undeclared, depending on how you want to look at it. It becomes a non-constitutional issue, which means you can't really stand under the Constitution or ask them to stand under the Constitution or the jurisdiction thereof because they're telling you it's a non-constitutional issue. The remedy is in the law. Please feel free to look up the United States codes, the USC, because the remedy is in the law. It always has been, and it always will be. The reason I say that is because there is not a legislator, there is not a judge, attorney, or lawyer that will ever willingly expose themselves to litigation or incarceration. The remedy is in the law. You will always find the equal and opposite. You will find the remedy in the law. So, with that said, if they say that it's not a First Amendment issue, it's not a Bill of Rights issue, it's a non-constitutional issue, and say this is declared emergency, we've suspended the Constitution, the USC still stands. It's been accepted by all 50 states as late as the 1970s. I think one of the last states to agree to it or stand under that jurisdiction of the USC, of the United States Codes, was in the early 70s, if I'm not mistaken. If I am, please feel free to comment and correct me. I'm going to give you two, and they're back-to-back, and there's a reason why they're back-to-back and very close in the USC and the USC codes, and the United States codes. 18 USC 241 and 242. That is your redress. That is my redress. Let me qualify that. That is my redress. That is how I'm going to redress these grievances. Okay? Again, not legal advice, information and entertainment purposes only. All right? 18 USC 241, 242. Look them up. Look them up. Okay? You're looking at deprivation of rights under color of law. And behind that is the redress, the filing that you can go when you name the names everywhere from your management, your lead, your manager, HR, legal, whatever state commission, the Civil Rights Commission, EEOC, all the way up to and including, everybody, whatever alphabet agency you wish to name names of. And all of their names are clearly, whoever's in charge of that department, Google it, include them. They're liable because it's under deprivation rights under color of law and conspiracy against rights, which is 241, 18 USC 241, conspiracy against rights. So all these people are in collusion and trying to force you to submit either by enticement, gift cards, lottery tickets. I've been offered paid time off if I submit to this, if their offer to contract is accepted, or coercion. And this is not just me. I mean, coercion, fraud, threat, duress, right? These are not offers to contract. But that's the next video. We're going to go through the 8 parts of a lawful contract. But I want everyone to understand this is not me against my company. This is not me against my country. Okay? It's not. It really isn't. The same thing is happening to my employer. All right? So the last 2 years, they've been taking all the federal monies. All the federal monies for COVID. That would be the enticement to follow these mandates and the guidance and procedures and the standards or whatever else you want to call them. Okay? They've accepted that money in the past 2 years. They've accommodated for work from home. They've accommodated, all of these things. The enticement they're offering to us is get the jab and get some paid time off. That's the enticement. Okay? So if you stand against them, they're going to lose all their federal monies, right? All the enticements for us are off. But then the other option is you're going to be charged $14,000 per infraction, right? So either take the money and comply, agree to contract, and if you don't, under threat, coercion, duress, we're going to fine you $14,000 per instance. They're in the same position we are. It's just at a greater level. And don't think that they have more to lose than we do, because we do too. We're laying this out. I mean, we're taking what is God's, what was given of us by God, and handing it to Caesar and saying, can I have it back now? This tastes bad. Okay, so that's the end of this one. So we've discussed the difference between color of law and positive law, the difference between administrative order, mandate, standard, code, rule, act, statute, versus positive law, which means amendment. And the difference being positive law impacts and affects all persons, and anything under color of law is for a specific class or classification group of persons, not all persons. Okay? All right. 18 USC 241, 242, go look them up, see what they mean, see what they say, and you'll realize that if they make this a non-constitutional issue, that's the direction I'm going. Again, this is not legal advice. I'm not a lawyer and I can't offer you any, but this is for entertainment purposes and information purposes only. Okay, next video is the parts of a lawful contract.